Good afternoon, Las Vegas. Clark coming to you with the herd. Welcome to what's left of America. Let's see, what should we talk about today? We got all kinds of stuff. Trump stuff, not really, kind of between election stuff here. So we can talk about legalities. What do you want to talk about with legalities there, Mr. In-house attorney? Did you want to say something legally?
Yeah, I wanted to do an in-depth evaluation pending the video or audio recording of the hearing.
Oh,
I've attended a lot of hearings with a lot of people, and it's amazing. I've attended some of them where we were interviewed when we got back out, and I heard some of the other people's interviews, and I was wondering if we were in the same courtroom. People hear different things sometimes. It's a pretty complex system as far as I'm concerned, and it's made a lot more complex than it needs to be. And I think that you are uncovering why it's that way. Because if they can create their own language, that the people in that specialized service, they can create their own language, they can charge a lot more money.
that's what it comes down to, is the money.
Always tracing the money.
And that's why they don't like pro se representatives, because that doesn't give the opportunity for, let's say there's a lawyer on the other side. What they like to do is the lawyers like to go to lunch with the other lawyers and figure out how much money each of their clients have, so they can figure out, well, you put in motion number 233 and I'll put in motion number 466 to combat your motion number 2, and then we'll go and we'll put in a motion this number and that number. And that should use up another $5,000 or $10,000. And then let's meet here after the motions are heard next week, and we'll figure out what motions we file after that. And that's what goes on. It's a concerted conspiracy to attack the plaintiff's and the defendant's wallet to get as much money as possible from each side. Now, a bailiff in the district court here told me one day several years ago, just in talking, waiting for things to start or whatever, just gossip. And he said, well, these cases usually...
When do cases end, right?
Yeah, these cases usually end when the parties run out of money. That's what the bailiff said. That's his opinion after watching case after case. That's his job. He's just in the court. He's just, watching cases. They always end when the people run out of money. That's his view, and it's a pretty accurate one. And that's what it's all about. I know in my particular case, it's all about the money. And the problem was there was never any money to attack here in Nevada other than what my sister had stolen from New Hampshire and put in her bank account here. That was it. Well, she got a lawyer involved that thought somehow he was going to end up with some of my sister's potential assets held in a trust for her in another state. Well, this lawyer either didn't know what the hell he was doing, or was so greedy he didn't care, or his whole operation is to just muddy waters up so much, and maybe this thing will settle out. And when it settles out, of course, he'll get his legal fees thrown into the mix, so he gets paid. Because he's not going to get paid.
No, settle out. Isn't that what they were encouraging today?
That's what they've been encouraging all along. And it's the lawyers encouraging the settling, because that means they get paid. If this thing doesn't settle, they don't get paid.
Well, if they have to rule one way or another. I did have a client that I ran into one time. I was down at had a friend in the public defender's office, and I hadn't seen him for a long time, and I was in the neighborhood downtown, and I went in there. I happened to meet her. She was waiting to talk to the receptionist, and I don't know how she got there. I don't ever believe in accidents. She had a civil case against her daughter. She was an elderly lady who her daughter dealt coverage at Caesar's Palace, and she had put together a real estate deal, and she wanted wanted it in her mother's name, probably for asset protection and probably for income tax reasons. And she was looking for help on her case, and I helped her some, and I put it together, and she was I give her credit. She was a strong. She reminds me a lot of you, Clark. She's a strong old bird, and she's not giving up. She's mad as heck, and she's not going to take it anymore. I helped her. I tell you, I didn't have a lot of hope at the arbitration hearing, but one thing that I didn't take into account is the mother that I was assisting. She didn't have any money. Her daughter had an attorney. So it was the battle of the little old lady that's mad as heck against an attorney who's getting paid by a dealer at the Caesar's Palace. And I explained to the daughter the first time I said that, you know, I told her, I said, we need to talk to your daughter. Can we meet down there sometime when she's on shift? We aren't going to berate her. I'm not going to attack her. I'm not going to do anything. It wasn't that long a conversation. I just said hello and said, I'm a friend of your mother's. And I didn't even think about what I was saying, just trying to communicate with her and be truthful. But about a year and a half later, after the mother had won the arbitration hearing, of course, that fits your pattern too. Only you won. In this case, the only one with money lost. And I was real surprised by that. But they have a right to continue on the trial. But I had told the daughter, the dealer at Caesar's Palace, that your mother's not going to, typically these things, one side gives up when they run out of money. But I promise you, your mother is not going to run out of money, because I guarantee you what I'm charging her is nothing. And I don't ever lose because I don't ever give up. When I enter the field of battle, and that's the way I've been taught by Right Way Law and other patriotic legal organizations throughout the country, when you decide that you want to enter the field of battle, whoever leaves first loses. Now, it helps if you know how to do it yourself. One reason I asked that we consider doing this was I wanted to tell the story of George Gordon. He ran a common law school in Missouri. I think he's passed away now. I'm not, to tell you the truth, I'm not real sure, but if he was still alive, he'd be in his late 80s or 90s. I went back to Missouri and took a week-long common law school class from him. He had a business that had EPA requirements. And just like most business operators, they don't want to run afoul of the law. So what can we do? There's 3 partners. What can we do? Well, we can get an attorney, put him on retainer. He doesn't have to do anything. All he has to do is study the EPA regulations and keep us out of trouble. That sounds like a reasonable, it's a minimal expense for the business that they were engaged in and the profit that could be made. So that seemed like a reasonable approach. I would think most businessmen would agree to that. Well, the first year they were cited, it cost $700, and they lost when they went to court. The next year they were cited again, $1,200, $1,300. They lost in court. The third year they were cited again. They went into court, $1,800, $1,900. George was a very principled individual, and he says, something's wrong here. We're paying you to keep us out of trouble. He said, well, I can keep you out of trouble. Here's my price to appeal this. I guarantee we'll win. This is what it cost you to win. They want $1,800. It cost you $5,000 for me to handle the appeal. I won't get paid unless I win. George said, sounds good to me. Let's do it. Both of his partners said, George, are you crazy? Why the heck would we pay $5,000 when we only have to pay $1,800? George said, don't you see these people are coming back like clockwork? We're a sheep, one of the sheep to be shorn on an annual basis. So he says, let's at least talk to the attorney again. Set up another appointment, come in. He says, what do you $5,000? What are you planning on doing for that? He says, tell you the truth. He says, I've thought it over. He says, what you need to do, he started his explanation with that. because he was about to lower the boom on him. What you need to do is bring a Fourth Amendment equal protection argument, the Fifth Amendment due process, the enforcement, unequal protection under the law, the Fifth Amendment. You bring those three claims, and the appellate court, you cite the cases, and they're in support of a case like yours, and they'll rule in your favor. He says, well, that sounds good. You said it was 5,000, right? He says, no. He says, I've thought it over. He says, if you think back the way I started, I said, what you need to do. No, he says, I can't do it, and I don't think you're going to find anybody that will do it. But you can do it. I can't do it. My wife, my children, they like the standard of living that they've grown accustomed to because of my legal practice. And if I actually do that for you and win the case, I'll probably lose my license and have to go look for a different type of employment. So George did it himself. He won the case. He stayed in the field of battle until he won. And he turned it into industry on his own. He began to teach people how to do it. So that's my suggestion. If you can draw a parallel, if you want to win, you learn as much as you can, as fast as you can, and put it into practice. And when your case, this is the key element that I told Victoria, when we first started on her case. This case is over when you say it's over. But if you can't afford to keep it going, you're not going to win.
Well, this case is has the elements of one side having money, the other side thinks they have money, but they don't have money. So they're not getting paid. But they're trying to get paid by going to the judge, asking for an award of fees on their side of the case. But first of all, they're the defendants. They lost the case, so they're the judgment defendants. They have no right for any legal fees for all kinds of reasons. I could name statutes, I could name trust law, I could name the American rule. They lost, okay? So they don't have any right for any fees. But they keep going to the judge, trying to get fees, and the judge's propensity, because he used to be a lawyer, is to award all the fees. All lawyers need to be paid. Just pay, 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 pay. But in this case, you can't pay. So my motive is to stop the lawyers from being paid, because there is no money. Technically, there's no legal money here in Nevada to pay them.
Well, I think that the publicity that you've given this is a gigantic step in the right direction. Without that, they might already be getting paid from the money that's left over. I was there the one day where he said, he kind of scolded you. Well, Mr. Feeley, lawyers have to be paid. You may want to give out the phone number. If there's a lawyer or somebody with a legal background, there's one point that I have never seen in my life. If anybody with any knowledge or seen this before or knows the rationale for it.
702-493-5222 is our number here. Give us a call. 702-493-5222.
The contingency agreement that your opponents and defendants entered into with an attorney had a contingency on agreement, basically. Every one contingency agreement I've ever seen, it's usually in a personal injury case of some kind, where the action is going to be brought against an insurance company, which obviously isn't the case here. But the contingency is that they prevail in the lawsuit. In other words, if you're injured and your attorney brings a lawsuit for car repairs and any injury that you sustained in the accident that wasn't your fault, he knows he's going to get something. It's usually in the neighborhood of a third to half if it would happen to go to court. I think one attorney here in town had an advertisement. I saw he was like 10% less. It was 29%. It was not like that. But anyway, it's dependent or totally related to the outcome of the case. You win the case, you get paid. An attorney that takes a case like that and loses the case, he doesn't get paid. But, you prevailed at the first level by getting the defendant removed as trustee, and, because of the proof that you provided that the trustee was in breach of the trustee's agreement. And now somehow your opponent's attorney is demanding payment for the case he lost. And I've never seen that. Your case is certainly unique in that respect. If there's anybody that with a law background that'd like to try to explain that to us, I'd certainly love to hear it.
Well, I'll explain it to you. The system here in Nevada is that you elect your judges, and that means they have to campaign to be reelected, and that takes signage, takes money, takes advertisement, whatever. And where they raise their money from for these campaigns are, of course, from the lawyers that practice before them in the court. That's kind of like legal extortion, if you will, because you're not going to get any favorable rulings with this judge if you don't reward him through campaign contributions. So the whole system is a phony, baloney extortion racket by these judges getting money from lawyers. That's the first problem. We have to throw out this electoral process for judges because it is corrupt. Okay? If I tried to give money to a judge, it would be a bribe and I would go to jail. The lawyers do it routine. Not only do they do it routinely, they're expected to do it, or they're never going to win a case. So that's number one. Number two is the judges have a propensity to pay all the lawyers, because how else are they going to get money in their kitty if they don't pay all the lawyers? So it doesn't matter what the law is. It doesn't matter whether they can or they can't pay. If there's money lying around, they're going to pay the lawyers. So the problem in this case is there is no legal money lying around. All the money that's here was gotten through bank fraud because the sitting judge signed an affidavit stating that the cashier's check that I have in my possession to protect the trust from this very shenanigans is lost, stolen, or destroyed. It's none of the above. And they know it, but they signed a fraudulent affidavit, and lo and behold, the bank that has an obligation to pay the check has the documents from the court saying the check's lost, destroyed, or stolen. So they send the money to this Nevada judge. The Nevada judge knows that I was going to appeal this case. So when he made his order to sell a home in another state, which he couldn't do, I'm waiting for him to finish the order, finish his ruling, and apply the legal fees. If he's going to award legal fees, do it, and then I can appeal it, right? Well, he wouldn't finish the order because he hadn't gotten the money yet to pay the lawyers. The second he got money from this bank, he told his appointed trustee, because he removed me as trustee without cause, because he needed a tool that he could use to write the checks.
Did
so
you have a hearing on that, or of some sort?
No, I wasn't in state. I wasn't here. He just removed me without cause for contempt of court because I wouldn't turn over the check to the court.
Were you represented at that time?
Yeah.
Were they given notice? Do you know?
Yeah.
They were given notice of the hearing?
Yeah.
Did they attend? Or?
Yeah.
Because although I saw several of the hearings, I don't remember seeing that one.
The judge removed me because I wouldn't turn over the check. And my lawyer objected strenuously and said your finding of contempt of court is not applicable because he, first of all, the only way you got to hear about this home in New Hampshire was because he brought it up in the court. He mentioned a particular trust in New Hampshire that his sister was a trustee of. It just got mentioned here. You don't have jurisdiction over that home.
And did he issue a contempt? Or
yes, and he also issued a bench warrant for my arrest. And the way I can get the bench warrant quashed is if I turn over the check. Well, I thought the check was lost. Well, what's going on here? So the judge is trying all these tricks. Why? To get the money. Why does he want the money? Not that so he can give it to beneficiaries and be nice and fair and split up the money the way it was supposed to be split up by the terms of the trust. No. He was going to pay his lawyers $600,000 on a $50,000 theft. My sister stole $50,000. Half of it was her money.
So she stole $25,000. And this judge thinks he's going to award her lawyer that's working on a contingency $600,000. That's the crime. This is a criminal court. And by that I mean they're the criminals, okay? This judge participated in this crime when he signed an affidavit stating that this check that I won't turn in is lost, destroyed, or stolen.
Now,
He is a
was the
despicable
individual
judge.
who signed the affidavit, do you know if he was in the courtroom when the judge issued the
Yes,
bench warrant?
He's
Were
a
you
losing defense attorney.
demanding that the only way you could get the
Yes,
warrant quashed was turning over the
He
check?
was my sister's attorney.
Did he speak up at all? Did it say,
Of course not, he's gonna get paid. He's not gonna speak, he's telling the judge to do it.
Wow, if I had committed a criminal act and the judge made on the record the fact that my affidavit was wrong, I think I'd certainly speak up.
He's a crook. Nobody's gonna speak up, they're all in on the crime.
Well,
And the lawyer's making statements like this on the record, that I plan to do this all the time. From day one, I planned to do this, steal the money from the house somehow. And the house wasn't ever to be sold. I didn't want to sell the house, I never would have sold the house. But the judge dictated that this losing defense attorney arranged to get a New Hampshire broker to sell the house. So in other words, the losing defense attorney was gonna be involved in the sale so that he somehow could finagle his $600,000 out of the deal.
and then you went back there, got as the trustee, because you hadn't been removed, or because you weren't given
Well,
the notice that you
technically
had been
speaking,
removed.
Technically
And
speaking,
you got it closed before that
the
question
trust,
ever arose?
the trust agreement that my mother had provided for me and my sister as co-trustees, okay? My sister got my mother to sign another piece of paper shortly before she died. She'd suffered from Alzheimer's for 4 years. My sister somehow got something, whether it's her signature, I don't know. But somehow she came up with a document that this court accepted being a legitimate document, which I still to this day say it wasn't. But anyways, making her sole trustee. So when the judge here removed my sister as trustee, that by New Hampshire law made me trustee.
Oh, you
No.
were co-trustees.
Right, so I am the trustee, I'm the only one left standing. And the judge also kind of concurred with New Hampshire law by following it for one example, and he made me trustee. So he made me trustee, but I didn't need him to make me trustee because the law made me trustee. And anyways, then he turns around with a scenario that, well, he made me trustee, he could remove me. So he removed me as trustee, but he never made me. I mean, you can go pound sand. You know, they all lie. They say they say things that have no meaning because they're just trying to cover up. Or they're snakes. They're all snakes. It's like when he said in the affidavit that he signed, he feels the court determined it's in the best interest of the beneficiaries that the bank send the money, return the money to Nevada. The money was never in Nevada. So how is it in the best interest of the beneficiaries that the money be returned to Nevada so that he can distribute 600,000 of it to his lawyer buddies? How is that in the best interest of beneficiaries of a spendthrift trust? And a spendthrift trust, a court has no jurisdiction over a spendthrift trust whatsoever.
That should have been in the first page of any document that I would have filed.
It's the law, it's law 101, okay? And the Supreme Court of the United States has made rulings exactly on point to where states can't do this between other states. Only property in the state, only the state that controls the property inside its borders can control that asset. No other state can interfere with that. Now, another state can make some kind of a judgment or whatever, and then the party that wants to uphold the judgment, if he wants to try to attach property or what have you, has to come to the state where the property exists and get that judgment that he may have domesticated in that state. So he has to kind of like file another lawsuit to get that judgment upheld in that state. Well, any state, the trust law, New Hampshire would never uphold another judgment against one of their trusts, because it's the whole purpose of having a trust is you got to protect the property. That's why people go through the expense of getting a trust, is to protect the beneficiaries.
Yeah.
So the whole thing is totally illegal.
I certainly understand the argument, I just don't see it in practice very often.
You never will. I've looked up millions of cases, okay, literally, millions of cases.
As far as the protection that a trust provides, it looks to me like they go through these attorney set up asset protection vehicles. They go through them like a hot knife through butter. They don't. It doesn't look like it. If they get their hands on it or get the jurisdiction over it, it's gone.
With or without jurisdiction, they don't even need jurisdiction. What it comes down to is the integrity of the judicial system in any state. If you have a trust, if you decide to create a trust like in Nevada, you better not, because the judiciary integrity in Nevada is an F, the worst you can get. You can't get a G that I know of. That's F is the worst grade, failing. Okay, that's the judiciary in Nevada. It fails. Okay, so you can never set up anything to have protection legally like a trust in Nevada, because the judiciary, like this Judge Earl, will just rule any way he wants to and give your money away to the lawyers. Like Judge Gephardt, you have to understand something. All lawyers need to be paid. Well, they can't, Judge, because this is a trust. Doesn't mean anything to this judge. He doesn't know what a trust is.
I know today they talked to you about figuring out what you want. If I had a magician's wand, and maybe you can't really come to a complete explanation of everything that you would want in this instance, because I've been in that situation before. I'm not sure what I want.
Oh, I know exactly what. I know exactly.
I want the people punished that put me through all this.
Oh well, that's.
But I, you know, it's hard to envision. What do you want to? I'd like to be made whole for what I've lost, but that's not enough. If I allow this to continue, my feeling has always been, and I'll see if you can agree with this or not. My feeling has always been that if I allow this to continue, the next person that they do this to, I'm a party to it.
Well, this is why I'm going through all this, because I'm a big boy. I'll be fine, and I have that cashier's check, so I'm not worried. But I'm doing all this to inform other people and to make a record of what went on here, because there's no cases that I can find that exactly match mine in the blatant, obvious illegalities that were done by a court. In this particular case, the court is the criminal. So how do you go into a court to get them to straighten out the fact that the court did a crime? What do you go to the criminal and say, straighten this out?
Well, I think you better go with reinforcements. I think there's a way you can do it.
Well, yeah.
I think what I would suggest, and I'll leave you with this final thought. Thank you for your time here, allowing me to offer any suggestions. And this will be my last one, because now we're facing the roadblocks that people encounter. But we had the gentleman here that has the shutdown Bank of America, has a lot of contacts with a lot of people. I'd say get in touch with him. Your case isn't exactly the same, but there's a lot of people that listen to his stuff that would be very interested in what you're doing. And I still get the feeling that if you had that hearing today and the courtroom was standing room only, with 1,000 or 2 people that out in the streets that couldn't get in, I think you'd be taking it, looked at it in a different light. So that's,
well, I think
it's something to think about. I'm a member of HERD, folks. I heartily encourage you to do something. Don't wait until they come for you. They're coming for Clark. They're coming for other people every day. These are psychopaths that are short on money. And Thomas Jefferson warned us about it. Do any of us know a government that's short on money? Thomas Jefferson said a government that's short on money is not to be trusted. So I wish you the best of luck, and I admire your fortitude and stick-to-itiveness.
I can read the law.
Now show us that you're in the fight to win.
Well, I can read the law. I know what the law is, and this court has violated the law not once, twice, three times. They have, in a conspiracy, in a scheme between the judge and the lawyers, they have broken about every single friggin' law you can break in regards to this particular case, because it was a conspiracy from day one to steal the money from a bona fide, legitimate trust created by dead people that were saving their money in trust for their beneficiaries. These judge and these lawyers hijacked that money from dead people and stole it. And that's what they did. And how they look themselves in the eye, I don't know. But that's what their business, that's what their enterprise is all about, is to steal the money. And that's what they do. And that's what this is happening here. So what needs to be done is very simple. This judge overstepped his bounds. He did not have jurisdiction to do what he did, subject matter jurisdiction. And what entails there is that, where is the property? The property wasn't in Nevada, so this judge had no authority, no jurisdiction to dictate that that home be sold. So that's completely out there. His order to do that is void. Now, that's part of the trust case that was here, this case. He had no, they're all void. Every order is void. I knew that when I read the order that he made dictating that that home be sold and that the losing defense attorney be in charge of selling the house. I mean, I never heard of such a confliction of interest. Jesus Christ. So anyways, I went right back to New Hampshire. I sold the house, and then to protect the money, because the judge and the lawyers out in Nevada were going crazy trying to figure out how to have an investigation, get the FBI involved, and the Department of Justice, and I must have done something to sell that house so quick, and they had to get the money, and blah, blah, blah. So they were talking about overturning the sale, and this was a miraculous sale that I pulled off. I got $600,000 more for the house than they were even gonna list the house for, let alone what they were gonna net if they should have sold it. They would have netted $1 million on this property, because it would have been a fire sale, and they would have been lucky to get $600,000 at the end of the day. They would have been lucky to get that. But anyways, I got way more than that. And then to protect any more interference from this out of control judge, an out of state judge who should have had no authority whatsoever to protect the trust further, I got a cashier's check. And that's as good as cash. My banker told me, because I asked him for cash. I said, give me the money in cash. He said, you don't want to walk out of here with over $1 million in cash. So he said, just take a cashier's check. It's the same thing. It can't be stopped. It's whoever holds that check, it's got the money. So I said, okay, so I got a cashier's check. Well, then Judge Earl's back into action, starts trying all kinds of tricks to get the money for that check. He tries an injunction, he tries a temporary restraining order, he tries everything in the world thrown at the bank. They even hired a lawyer in New Hampshire to sue the bank to get them to not honor their check, and then get an injunction and this and that, and all these tricks. But all these tricks don't work because a cashier's check is considered to have cash equivalency. And that means that as soon as you get the check, you've been paid. And there's no way they can overturn that. No court can interfere with that or anything else. The bank's obligation is then to return the money that they got from the check back to whoever holds the check. In this instance, it's the remitter, me, that has the check, so they have to pay me. Simple as that. That's the way it goes. And this is, so I did that, and then Judge Earl, he finds out through the bank that the bank said the only way that they can stop payment on a cashier's check is if there's an affidavit signed by someone that's gonna take responsibility for the payment of this check and declare that the check has been lost, destroyed, or stolen. Well, okay, the judge, this despicable, illegal judge, hears that, says, well, that's fine. I'll just sign an order saying to enter an agreement with the bank that the check's lost, destroyed, or stolen. No problem. So he does that. He signs this affidavit, signs this order, files it with the court. They send it back to the bank in Nevada and New Hampshire. And the bank in New Hampshire, I mean, despicably, really, this was a funny deal too. And I think there was a bank officer that got paid off to do it, obviously. So he sends the money to Nevada. Well, the second the judge gets the money here in Nevada, I have been holding the check, and every time lawyers or people get a hold of me about the check, they're gonna throw me in jail if I don't turn over the check and this and that, I would respond, say, just finish your order. File a final order in the case of Nevada, so I can appeal it. And then we'll see what happens in the appeal, and we'll go from there. But you have to finish your order. You can't do this in the middle of your order without doing it, without finishing it. So he knew the judge knew that I was gonna appeal the case. So he had to get the money in his hot little hands so he could distribute it before I would appeal it. And that's what happened. He got the money from the bank. He told his appointed trustee, his friend, somebody, the CPA that he knew to play trustee, distribute the money to the lawyers. So he paid out $600,000 to the lawyer the day he got the check. And he had not, at that time, issued an order, a final order that I could appeal. So I couldn't appeal anything. I didn't even know he was doing this. Because what he was doing was against normal Nevada procedures. You can't pay money out on an order before you file the order. Well, he files the order finally after all the money's gone, and then I immediately appealed it. So the courts here in Nevada are completely crooked. Now, the appeal court finally weighs in and affirms Judge Earl's decision, which is one of the funniest affirmations I've ever read. Well, it's not funny, it's obviously blatantly false, but what have you. They say that the court here in Nevada had personal jurisdiction. So they affirmed the judge's ruling because they had personal jurisdiction. Well, my appeal raised the issue of subject matter jurisdiction, which is altogether different from personal jurisdiction, and it's definitive. If you don't have subject matter jurisdiction, personal jurisdiction doesn't matter one way or the other, you can't make a ruling. So that was what I appealed, and this court does not have subject matter jurisdiction. Why? Because the property wasn't in Nevada, period. End of case closed. So the appellate court, in their affirmation, didn't address the issue that I appealed. What kind of court is this? This is a court that's covering up for the judge that made the ruling to start with, covering up for the crime that the judge committed, covering up for the fact that the court system here in Nevada is completely an F, failing grade with no integrity. What are they covering up? Everything. The crime was committed by the court. So how can I ask the court to make an appeal that holds them accountable? Never, ever will they do that. Because the court is criminal, it's broken, it's corrupt. So it's terrible. This whole situation is bananas. So anyways, technically now, if you want to speak legal terms, and someone can call in and straighten me out if they want, 702-493-5222, and let me know where I'm wrong, but here's the way I have the legality. The Supreme Court has weighed in that any state, such as Nevada, cannot control any trust assets that are held in trust in another state. You can't do it. So that's that. The Supreme Court has weighed in on this, and that's the law of the land. The Nevada Supreme Court has a constitution that they have to live up to, the Nevada Constitution, and in that section, Article 1, Section 2, I think it is, or vice versa, Section 2, Article 1. I think it's Article 1, Section 2, specifically states that the Court of Nevada has to uphold all upper court binding decisions, like from the Supreme Court of the United States. They must follow and abide by all prior precedences, because they're considered controlling. So any decision from the Supreme Court of the United States would control a Supreme Court decision here in Nevada concerning the facts of this case, which can Nevada interfere with the title or control of real property in another state? The definitive answer is an absolute no. They cannot. And that's been determined by the Supreme Court of the United States. So it's the law of the land. So no matter what the appellate court has said, they need to clarify Well, this district court needs to send back to them and ask for clarification, or somebody, I'm not gonna do it because I don't have to do it. This court has the burden to prove that they had jurisdiction to do what this Judge Earl did, and they don't have it, and they can't prove that they do, so it's gonna fail. So every order that they've made, everything that they did, that cashier's check is another whole matter, but that's a fraudulent, that's bank fraud is what that was. So there's a compounding of things. The judge couldn't do what he did in trust law by the Supreme Court of the United States, by other case called Henson versus Deckler, case called Penowa versus Neff, case called Livingston versus Jefferson, Overby versus Gordon. These are old 1800 type cases. They go back to the beginning of this country. And that's the way the law has always been. It's never been overturned. It's never even been questioned. These things where one state tries to control another state's property has always been considered absolute nullity. So anytime anything like that ever comes down the pike, it's void immediately and has no weight or force attached to it whatsoever. So that's the law of the land. I'm sorry, that's it, Nevada, you lose. I mean, you didn't lose anything. Well, you tried to steal money and you didn't get away with it. So anyways, what needs to be done now is there's $60,000 sitting here, that's my money, that's actually held in another trust. My mother had two trusts. One of them, Judge Earl got right, that my sister and I owned it equally. And my sister had already stolen all the money out of the trust, but accidentally there was some stock left over that I guess she didn't know about or have a chance to steal yet. So now that was 60,000 of that was left over that she didn't steal, so now it's sitting in a bank. And that's my money. And Judge Earl had awarded the fact that half of whatever that was in that trust was my money. She's already gotten over $90,000 out of that trust. And there's only 60 left over, so it's all my money, 100% of it. As a matter of fact, she owes money to the trust that she needs to reimburse. She has jewelry worth about $100,000 that she needs to give back. She has furniture worth in China and other things worth money. And she owes, according to Judge Earl, made her responsible to reimburse the money trust $26,753, which she has yet to pay back. So she owes money, and all that money is my money, and I want it. And then that's it. That's the only thing really that's mine that the state of Nevada has control over. Now, they stole money on the cashier's check deal from a bank in New Hampshire because they created bank fraud. And that's a criminal offense, a Class A felony, punishable up to 30 years in jail and $1 million fine per count. And Judge Earl is guilty of that. And he signed a fraudulent affidavit. And the state of Nevada, being that he was a district court judge in Nevada, will end up being responsible for that. The lawyers that got that money paid out of the trust are gonna have to give that money back, or they're gonna lose their license to practice law in the state of Nevada. So this is serious, serious business. This isn't child's play, okay? Serious, serious laws were broken. You violated trust law. You destroyed a family. You stole dead people's money. I mean, how more despicable can a court be? You're a bunch of criminals. So it's time to pay the piper. So what needs to be done, an order from the Supreme Court or whatever, confirms the fact that they didn't have subject matter jurisdiction and makes a requirement that the money be returned that's been dispersed from that account that holds the leftover. And then once all that money's there, they'll have to work out something with the bank on what else they need to send to the bank to get them off their back. Because the bank's gonna come knocking on the door asking for that money. And, you know, the bank has some issues too, because they entered an agreement that I say they knew was false when they entered it. I can prove that. So there's been all kinds of shenanigans going on here, and they were all done by lawyers who passed themselves off as being officers of the court. And that's the way they get away with all this crap, because they have some sort of contrived authority, but it's all misplaced because they're all crooks. And they all take advantage of the law and they abuse it. and they abuse their positions. And they do that, they reward themselves and enrich themselves. And this is exactly what went on here. So we have a lot of straightening out to do. And we're gonna have to get it done. In the meantime, this court over here, this district court Gephardt, needs to award me my $60,000 and then needs to just do whatever they do. If they wanted to get put on their pants and do the right thing, they would void out all the orders that are made that need to be vacated because they're all illegal and get the money back whenever it can be recovered. My sister's lawyer has died, and he got about $400,000 in this mess. So how you get that back, I don't know. I guess it needs to be returned from his estate. The other lawyers that are trying to be fed at the trough here need to all pay their money back, because the pure basics 101 of a spendthrift trust is that the principle is that a person that had the money, the settlor, left their money in trust for their beneficiaries. And the trust is a relationship between the beneficiaries and the trustee that was designated by the settlor. So the trustee holds the money with the instructions that are in the trust document of how the money should be dispersed. And he has to follow to the letter that trust document. And he cannot award or pay any money out that's not provided for in the trust agreement. And that trust agreement, no court can interfere with that, no judge can interfere with that, because it's the settlor's last wishes. So it must be upheld. And so the judge doesn't have anything to do with this, really, when push comes to shove. So they just have to wash his hands of it and say, at this point now, it's between the bank and the state of Nevada, or perhaps the Attorney General, have to straighten this cluster mess out, because it was caused by Judge Earl trying to reward his lawyers so that they could turn around and contribute to perhaps his campaign or other judges' campaigns or whatever. The system is about getting all the money that can be gotten, awarding all the fees that can be awarded to all of the lawyers all the time, because that's the way the system works. I equate it to like a poker table. Here you come in from Des Moines, you're the firehouse guy that's the best poker player in town, and you really know the game, so you're gonna come here to Las Vegas and get rich playing all these dummies out here. And what happens to you is you walk into a poker room that has a table with maybe 5 or 6 professional, full-time poker players sitting around there that are all from Las Vegas. And their job, as a union, if you will, sitting there, is to get your money. You're the new blood. You're the idiot walking up to their table, and you're going to get taken. And they're all going to gang up on you and make sure that you don't leave with a dime. And this is the way our court systems work here in Nevada. All the players sitting at that table with the lawyers, waiting for some dummy plaintiff or some dummy defendant to show up. The dealer is the judge who's dealing the cards. And there you are. That's your chance in life right there. You're going to get rich, dealing with a bunch of professional lawyers and poker players, whatever you want to call them, and a dealer, a judge, whatever you want to call them, and the game is rigged, rigged, rigged. You're going to get your pockets cleaned out, because the entire system here in Nevada is corrupt, period. That's it. Excuse me. That's the way it is. So now you know. That's what's going on in the state of Nevada, in the judicial system here. It is pathetic. And I never, ever, ever, ever would have gone anywhere near any system like this. I actually knew better, but I was just trying to get access to bank records. That's all I wanted. And the problem was that there was too much money involved. But I know the law, and I know the law, and the law protected it. This is a New Hampshire trust. What in the world's wrong? I just need access to the bank records. The bank records will show I'm right, that my sister was stealing money, and that's all that counts. That's it. So, no problem, right? Yeah, except I run into one of the crookedest, most incompetent, not aware of trust law judges in the state of Nevada, and maybe in the United States. This guy is pathetic. He doesn't know dick about the law. And he's a crook. He knew he was breaking the law, but he just kept on trucking down the road, breaking. See you tomorrow, America. Thanks for listening in Clark at the Herd. Give us a call anytime, 702-493-5222. We'd love to hear from you. I'd like to discuss with you anything you want to discuss about politics, the legal system here, if that's what you want to call it, the joke here in Nevada. It's the worst system I've ever come across in my life. Oh my God.